Welcome, everyone, and Happy New Year. I'm thrilled that we're able to get back starting our webinars. And with this is a follow-up webinar to the one we had in October, Do You See What I See? Talking about the science of eyewitness testimony and identification. We're going to be talking more about the details about eyewitness identification in today's webinar, and I'm pleased that our speakers, Judge Richard McKelvie and Professor Louisa Heiny, are here with us to present this topic. Before we start, I'd like to remind you that if you have a question, please use the Q&A feature at the bottom of your screen. Don't use the chat feature. Also, I want to remind you that pursuant to Utah State Bar rules, you have to stay for the entire webinar, at least 60 minutes, in order for us to submit your name for credit. So I just want you to know that ahead of time. And with that, I will turn it over to our speakers. And again, Happy New Year.
Thank you, Lori. And hopefully today's not a day for doom scrolling, and Judge McKelvie and I will be so entertaining that you'll want to stay for the full 60 minutes and watch us. We're going to start today with the same way that I start out my classes, which is with something I call a happy. Rich and I were talking about the best lineup cartoons and videos. And so we're going to play a video of my favorite best worst lineup. My kids and I have been binge watching Brooklyn Nine-Nine. That might say something about my parenting, but here we go with the best worst lineup. Charlie, can you play it for us?
So, do you recognize any of these men?
I was hiding in the bathroom stall, so I didn't see his face, but I heard him. He was singing along to the music at the bar.
Do you remember what he was singing?
I think it was that song, I Want It That Way.
Backstreet Boys, I'm familiar. Okay. Number one, could you please sing the opening to I Want It That Way?
Really? Okay. You are my fire.
Number two, keep it going.
The one desire.
Number three.
Believe when I say.
Number four.
I want it that way.
Tell me why.
Ain't nothing but a heartache.
Tell me why.
Ain't nothing but a mistake.
Now number five.
I never wanna hear you say,
Woo! I want it that way.
No, will you do that, please?
Oh, chills. Literal chills.
It was number 5. Number 5 killed my brother.
Oh my God, I forgot about that part.
Thanks, Charlie. Judge McKelvie and I were talking about how many mistakes we could find in that one lineup. Judge McKelvie?
Yeah, I mean, so to start out with, you have a witness who right out of the block says, I was in the bathroom and I didn't see anybody. So why is she looking at anybody? That's the first thing. The second thing is you look at the lineup itself. You have, I think right off the top of my memory, either 2 or 3 African-Americans, a couple of Caucasians. One of them is like 6'4", the other are like 5'7" or 5'8". Some of them have facial hair, some of them don't. There are almost too many things to enumerate with respect to why that wouldn't work. But in my view, it starts right off the top at it. Why would you present a lineup to somebody who was already indicated they didn't actually see the person?
And for a voice lineup, she shouldn't be viewing faces anyway if they were going to do something along those lines.
Yeah.
So today we're going to talk about the second half of eyewitness identifications. Last time we talked about Rule 617, why it exists, what the science is behind it. Today, Judge McKelvie and I are going to discuss the ways that you litigate the rule. And the way we're going to do it is chronologically. So starting with the language of the rule, thinking about motions in limine, all the way through what might happen with experts at trial and jury instructions at trial. So we're starting with the language of our rule that tells us that the court shall exclude evidence if the party challenging the evidence shows that a fact finder, considering the factors that we talked about last time, could not reasonably rely on the eyewitness identification. And the judge can consider things like opportunity to observe, level of attention, things that we talked about like same race bias and weapon focus. So let's start with motions in limine. Judge McKelvie, Are we, as defense attorneys, we filing a motion in limine as part of our stock instructions every single time?
I obviously not every single time. I think that you really need to look at it and analyze it. There's no point in litigating something like this that looks like everything has been done correctly, but you really need to look at it to find out whether it has. Determination is going to be made based on a lot of factors. Which law enforcement agency did this? What are their protocols? If we're talking about the FBI or the Salt Lake City Police Department or Unified PD, which have really experienced, well-trained detectives who have a protocol that they're supposed to go through, that they should follow. You look at it, and if they followed it, it appears obvious that they have. It's no different than challenging a search warrant. There's no point in doing that if right out of the blocks you can see that it's a good search warrant, it's valid on its face, the execution of it was appropriate. Then you're not going to waste your time, the court's time, and your client's money, for that matter, challenging something that appears to be, I mean, from an admissibility standard, as their standpoint, just solid. But there are a lot of different things that you ought to be looking at and questions that you should be asking to decide whether or not that's the case.
So the rule itself talks about some of the best practices, cites to articles, so that the advisory committee notes cite to some of the key articles and experts in this topic. Do you think that we need an expert affidavit where we are filing a motion to suppress one of possibly several eyewitness identifications in a case?
I think it would certainly be helpful, because what your objective is going to be, probably, if you're actually looking towards suppressing the identification, keeping it out of court, eventually you're going to want to have a hearing about that. And you would want to have an expert witness probably to testify about how suggestive the lineup was, the manner and the different manners in which the investigative agency didn't follow best practices, the ways in which there could have been some kind of bias creep into the process, or suggestiveness creep into the process. And those are the kind of things that, I mean, most judges don't understand. I've done this probably more than most, and I still don't. I'm not going to replace an expert's analysis with my own regarding all of the psychological factors, for example, that come into the things that we've talked about earlier: cross-racial identification, time, stress, weapon fixation, bias confirmation. All of those things that we've looked at that are going to come into play, that a judge is going to have to look into as a gatekeeper, right? I mean, as a first step, it's analogous to a State versus Ramash hearing, where you're suggesting to the court that this evidence is not sufficiently reliable, that a jury should even hear it, that the state shouldn't be allowed to even present it to the jury because of a lack of indicia of reliability.
And the good news is we have some of the key eyewitness experts here at the University of Utah, yes?
And have been for a long time. I mean, they've kind of been the vanguard clear back in the 70s and 80s, when this really started to become something that psychiatrists and psychologists studied, as opposed to just something that lawyers were studying. And some of the from the experience and the research that was done here at the University of Utah was really instructive on how fallible eyewitness identification can be, and particularly how fallible it is as it contrasts with the witness's subjective perception of how correct they are. That there's not usually, or not often, a correlation between how secure a witness is in his or her identification and how accurate that identification actually is.
We know, you and I talked about this, that an indigent defendant would unequivocally be entitled to the services of an expert at trial. What, if anything, do we know about the right to an expert at an in limine stage?
So I would think that a court would probably grant that in any motion to suppress the identification. That's going to be rarely granted, quite frankly, because just like with a search warrant or a confession or something like that, where there's kind of a two-prong test, or at least the procedure is in two steps. You can challenge it before the trial court as an initial matter, and if you're successful there and the trial court suppresses the evidence, then it doesn't come in at all, and that could be the end of the case. Just like the suppression of a confession could be the end of a case if that's the primary evidence that the prosecution is working on, or if there's a search warrant that has been challenged and the evidence is suppressed, could be the end of the case. But the defendant always has an opportunity, even if the trial court doesn't suppress the evidence, to challenge its validity and its credibility. I mean, obviously, if the judge says the process was okay, the investigators did the right thing, there's no reason that this witness shouldn't be allowed to testify, doesn't preclude the defendant from challenging whether or not that testimony is accurate. It's really kind of a threshold gatekeeper provision. And I don't see those kind of challenges very frequently, because I think that most defense attorneys recognize that only in the most, what they would refer to as egregious situations, like the one you just showed, on the Brooklyn Nine-Nine, where you'd look at it and say, like, there's absolutely no way that you could look at that and say that was an objectively reasonable way to handle the lineup. Probably your better bet is going to be just to argue identification issues with the jury and to have an expert witness testify about that, so that the jury is well informed about all of the pitfalls that are involved in eyewitness identification that a lay person probably wouldn't really understand.
So you and I were debating fruit of the poisonous tree as late as 11:54 this morning. This is something that I think is going to end up being litigated. So I think we probably have some newer practitioners and more seasoned practitioners on with us today. More seasoned practitioners are probably familiar with Ramirez and the idea in Utah that perhaps eyewitness identification has a constitutional underpinning. Lujan now tells us, State v. Lujan tells us, really the inquiry starts with 617. But then we've got some other language in Lujan that says, well, there's a Perry backstop. There's a due process clause backstop here. Do you have some thoughts, or maybe we can kick around the thoughts we had about whether a 617 violation can be the font of a successful fruit of the poisonous tree argument?
And after our interaction earlier this morning, I've given that some thought as well, and tried to look at some of the other cases. I think it's certainly possible. I mean, if it's just like any other due process violation, if you looked at it and you said, this is so egregious that, I mean, not only am I going to suppress the confession, or not confession, the identification, but it no longer has any indicia of reliability. And if this witness is allowed to testify in trial and the jury hears them testify, and there's no way to adequately really parse out whether or not the identification is the product of their recollection of the event or their recollection of the improper identification procedure, then the appropriate remedy would be to not allow them to testify at all with respect to identification. That doesn't mean that the witness couldn't testify. I mean, if you have a robbery victim and you have other evidence other than the identification that would support a conviction, certainly the robbery victim could testify that they were robbed. They could provide, I think, whatever general description they provided to the police before the improper lineup or show up or whatever it is that we're talking about, the identification procedure that is excluded. But I mean, number one, you wouldn't let them testify about the identification procedure itself. You wouldn't allow them to testify with respect to identification, and you wouldn't allow them to testify about any indicia of identification that was gleaned only as a result of the show up or lineup. So in other words, if you had a victim who gave a general description of somebody and it didn't include their eye color, and then they had an improper lineup or show up, and at that improper lineup or show up, they realized that the individual had some very distinctive looking blue eyes. The suppression of the identification would include suppressing that detail. If there was no, even if the witness would say like, oh, when I saw the guy in person, I realized those blue eyes really jumped out at me, but they didn't report that to the police. They didn't put it in their written statement. I think that there would be a really compelling argument that there's not enough trustworthiness that their identification of of the eye color is a product of their recollection of the event as opposed to their recollection of the procedure, the identification procedure that the trial court has already determined was constitutionally inadequate.
I also, when we're thinking about fruit arguments, fruit of the poisonous tree arguments, I think, but I'm interested in your point of view, both as a practitioner and as a judge, but I can envision a circumstance where we have for example, a show up. The show up is what generates the probable cause that might then result in a search warrant, and we end up with some kind of real evidence, documentary or otherwise, we find the weapon, etc. What do you think about the fruit of the poisonous tree in that circumstance and using the 617 argument as a way of suppressing later found evidence?
I think that that's a more nuanced issue, obviously, because as we analyze things under the search warrant provisions or the jurisprudence there, we know that if there's a good faith representation in the search warrant with respect to evidence, the trial court can rely on that, even if it turns out to be inaccurate, as long as the proponent of that information, the affiant, has a good faith basis upon which to rely on it. And so there are a number of circumstances in which a lay witness has provided information to police that it turns out not to be true, but the police have a good faith basis upon which to rely on it. They put that in the search warrant affidavit. That is then used to support the affidavit and the search warrant. And the courts have said, unless the police officers knew or had some good reason to believe that the information was inaccurate, even if it is inaccurate, it's allowed. And you could end up with a situation, I think, where somebody could give information in a lineup or a show up that gave investigators sufficient information to obtain a search warrant. The court could suppress the identification procedure and still uphold the search warrant because of that good faith exception. In other words, in order to exclude the search warrant itself as opposed to the identification, it would take a separate analysis, and the court wouldn't just have to determine that the lineup procedure or the identification procedure was constitutionally inadequate, but the police officer who engaged in that and then presented it to the magistrate signing the search warrant would not reasonably rely on the information that he or she obtained in that identification procedure.
Do we think at all, I'm a little troubled about the incentives there. Do we think at all about whether the officer did or did not use best practices as they're laid out in 617 in setting up that lineup or that show up, and perhaps with the, I'd say it, but nefarious intent of ending up with the affidavit necessary for the probable cause?
Yeah, and obviously that's something that you always have to encounter or look at it. It's not an allegation that often gets raised, but I think that if the trial court made a determination that there was some nefarious purpose, that the officers who engaged in the identification procedure intentionally prevaricated, that they either set it up in such a way that the witness was pointed toward a certain individual, or they didn't follow best practices in a way that makes it pretty obvious that they had a candidate in mind and they wanted to do everything they could to get this witness to identify the candidate, then you'd probably go through a Franks v. Delaware analysis and excise that information from the search warrant affidavit. And then with that information excised, make a determination as to whether or not there was still sufficient evidence to support a determination of probable cause.
Do you envision, if a motion in limine is step one here, do you envision these ending with motions to dismiss, or do you think that's just going to be incredibly rare? If you had a case, and I'll go back and equate it to a case where you have an unlawful search or an unlawful confession taken in violation of somebody's Fifth or Sixth Amendment rights, or Fourth Amendment rights in the case of a search. Oftentimes, a successful litigation of that motion from the defense perspective puts an end to a case. I mean, it terminates it. If I'm prosecuting a case in which a police officer pulls somebody over on the street, instigates an investigation that results in the uncovering of a quantity of narcotics, for example, and everything flows from that stop and that search, and the trial court says that search was constitutionally inadequate and suppressed the evidence, there's no evidence upon which to proceed. But if I have a similar case in which I have that stop, and then the police officer interviews the individual, and the individual admits, yeah, somebody hired me to drive these drugs from San Diego to Chicago. Here's how it happened. And trial court says, okay, the stop was okay, the search was okay, but the confession was obtained in violation of the defendant's Fifth or Sixth Amendment rights. I'm going to suppress the confession. Then the prosecution still has to decide, do I have sufficient evidence to go forward if the confession is suppressed, because I still have the fruits of the search. I still have that. I still have this guy in the car with the drugs, and strategically, tactically, you might think, because of that, there's a good chance he's going to have to take the stand in order to explain how it is he came into possession of this huge quantity of drugs without being aware of it, or without being criminally liable. And then at that point, you can cross-examine him about the suppressed confession, unless it's been determined not only to be a violation of Miranda, but to be so egregious that it was not voluntary.
It was an involuntary confession, and then it wouldn't come in under any circumstances. And you can always make that argument to a jury, even if the court lets it in, which kind of leads us to the next thing that we were going to talk about the two-step process, or the multi-step process in challenging these.
Before we talk about that two-step process, just practically thinking from the defense point of view, are there time limits or other strategic issues that defense counsel should be thinking about at the pretrial stage?
Yeah, I think so. If you are in a position where you think you have an identification process that is subject to challenge, that it's suspect for some reason or another, you want to approach it in such a way that does not allow the potential witness to have any other exposure to the defendant. So in other words, you don't want them identifying the defendant at a preliminary hearing. You don't want them necessarily looking at a lineup if they haven't already done that. Because if there's a question about the validity of the identification, you don't want that to be polluted, so to speak, by a subsequent introduction of the defendant or the suspect to the victim, because then it becomes much more difficult to try to ascertain whether the in-court identification is a product of the witness's recollection of the offense itself, or their recollection at some proceeding in which they were shown either a photograph of the suspect / defendant, or actually presented to them in person. And there are certainly circumstances under which a trial court might suppress the identification process itself, but still say, I don't find it so egregious that I'm not going to let this witness testify. And then that puts you in a real quandary as a defense counsel. How are you going to cross-examine this witness if the judge has said, I'm not going to let you talk about the pretrial identification process state, but I am going to let you put this witness on the stand. The witness testifies, identifies the defendant in the courtroom. How are you going to cross-examine that witness without disclosing the suppressed evidence, without disclosing the fact that they had seen him in a lineup? And are you sure that your memory is a result of the event as opposed to seeing this person in a lineup? And then it gets back to that bias confirmation thing that we talked about.
And you actually had a really good example of this from when you were a U.S. attorney. Where you had really tainted witnesses, right? Because they had been present at a hearing.
It was actually a long time ago, even before I was at the U.S. Attorney's Office, when I was at the county attorney's office, now the DA's office. And it was a very troubling sex offense. The victim was suffered from Down syndrome. So she was not, the most capable, right on top of things witness that you would hope for. The way the lineup procedure worked, and I assume it still works this way, is you take the suspect, obviously, you find a random group of people, usually from the jail, because they're a captive audience. You have them right there, and they're all already dressed the way they need to be, because everybody has to be dressed the same. Bring them into a room, there's usually 6 to 8 of them, and have them stand in a row. And it's on the record. There's a court reporter there. The prosecutor is there. The defense attorney is there. And typically the investigative agent is there. And then you have the witness or witnesses that are going to make the identification. And they're in another room, because obviously you don't want them to observe the process where we're talking, with the defense attorney is talking with his client. The case that I had, this was a sex offense, as I indicated, with a mentally challenged victim. And the defense attorney is usually given pretty broad discretion in where on the lineup his client stands, like number 1, 2, 3, 4 on down the line. And the way this was set up, the defendant was in position number 2, and there was another individual in position 4. And the defense attorney said, yeah, I want my client in position number 2. And then we sent the investigative agent out. After that, and this is important, after that determination was made, the defendant's number 2, the investigative agent went out to get the alleged victim. While he was out of the room, the defense attorney said, you know what, I've changed my mind. Number 2, number 4, change places. So his client went to the number 4 slot. The number 4 person went to the number 2 slot. The victim came in, she looked at the lineup, and she identified number 2. Now, whether the detective told her it was number 2, I have no idea. I'd never asked him about it. I never pursued that. I don't think he would have been honest with me about it. But it destroyed the case. I mean, obviously, I couldn't pursue the case anymore when the victim positively identified somebody that was not the suspect in the case, and that we knew couldn't have committed the case because he was incarcerated at the time that the events took place. I mean, he was just a filler, could have identified any of the other ones. And so that it makes you realize that those kind of things do happen, and that there's a reason that it's important to scrutinize these things really carefully, because whether advertently or inadvertently, prosecutors and police officers can make suggestive thoughts, can create suggestive thoughts that a victim or a witness will incorporate into their belief system.
We talked about that a little bit quite a bit in our first session on the ways in which we can the ways in which prosecutors or investigating agents can sometimes very accidentally signal to a witness overtly or implicitly, yeah, you got it right.
Right. Or you got it wrong. I think I told you about another case, and I'm not sure if we discussed this in our previous meeting, but even if we did, it probably bears repeating, where there was a lineup and there were two female witnesses to this crime. And one of them picked the person who was charged in the lineup. One of them picked somebody else out of the lineup. The next event that took place was preliminary hearing. Both of those women were subpoenaed to testify in front of the preliminary hearing. The prosecutor who was handling that case, who was supervised by me, I didn't find out about this until afterward, but brought both witnesses into his office together and looked at the one who I made the identification and said, okay, I'm going to put you on the stand to testify about this. And then looked at the other one and said, at the lineup, you picked the wrong person. I'm going to excuse you. You're not going to testify. Now, I can't think of anything, regardless, and I don't believe that it was intentional. I don't believe that he had any motive toward thwarting the veracity of the identification. But certainly what he did was validate the identification that the one witness had made. He's basically said, you got the right one, you picked the right person. And so when she gets to the preliminary hearing, her determination about who it was that committed this crime has already been validated by the prosecutor. And now at the preliminary hearing, unlike the lineup, he's going to be the only person sitting at counsel table.
That's right. It's the one guy sitting right there. Yeah.
In the jumpsuit, sitting in an orange jumpsuit, yeah. Right? With shackles and two deputy marshals or bailiffs standing behind him, and then once that occurs, you're done for. You can't possibly try to isolate and differentiate between an identification that takes place as a result of the witness's actual memory of the event, as opposed to more recent events where they've been exposed to the same individual or maybe a different individual. That's kind of the whole point, for much longer periods of time in much less stressful environments. If she's sitting in a courtroom testifying at a preliminary hearing, and the entire time she's testifying for 15 or 20 minutes, she's sitting there looking at the person, that's certainly more exposure than if she were the victim of a bank robbery and the robber was in front of her for 15 or 20 seconds. And then by the time you get to the trial, she could pick him out of a lineup like she could her own kids.
We talked about another circumstance in which we had you had accidental exposure of the witnesses to a confession, but a Rule 11 conversation.
Sure.
And then under the federal rules, the defendant ended up withdrawing his guilty plea. But under the Victim Rights Act, the witnesses had already been present for that very important hearing. Do you want to talk a little bit about that and how you dealt with it from the prosecution side?
It was a really interesting and unusual situation, but it really kind of hits at the square of this, where it was an individual that had allegedly committed several robberies of Subway sandwich shops. Called him the Subway robber. We brought it in federal court because of the there was just so many of them, and we used our federal kind of overreach statutes to bring him into federal court because the sentences were so much more severe. The defendant challenged the eyewitness identifications and wanted to put an expert witness on the stand at trial. We had a Daubert hearing about that. Unlike the state, at least in our state, the federal court judges have a great deal of discretion about whether or not to allow an expert witness testify about that. Judge Stewart ruled that because we had so much other supporting evidence, an expert witness would not be helpful to the jury. And so he denied their request to have an expert witness testify. After that, the defendant decided to enter a guilty plea, and we worked out a plea agreement under Rule 11 C1C, I think it is, that allows the defense and the prosecutor to agree on a specific sentence. And if the judge won't, after seeing a pre-sentence report, impose that sentence, then the defendant's at liberty to withdraw his plea. So we worked that out. The defendant came in and pled guilty, unbeknownst to me, because I don't, you don't pay too much attention to what's going on in the background. Our victim witness counselor had notified some of the victims that this guy was going to plead guilty. And some of these victims came to court and actually were present when he entered his guilty plea, when the judge asked him, did you commit these offenses, with a factual background? And he said, yes. So then the pre-sentence report was prepared. Judge Stewart looked at the pre-sentence report and said, I don't think 10 years is enough for this guy. And so I am not going to accept the plea. And then I became aware of the fact, and the defense attorney became aware of the fact that some of these victims had been present during the plea. And it created an impossible quandary, because if any of these cases went to trial, and it was our expectation that we were going to try them all together, if these victims came in to testify and they were going to identify this defendant as the person who robbed them, as a defense attorney, how could you possibly cross-examine that witness and ask them whether or not the identification they made in court was a product of their actual exposure to the defendant at the time of the robbery, or their exposure to the defendant when they sat in court and watched him plead guilty to the very offense that he's on trial for? And it was just, in my view, it was an impossible task for a defense attorney to engage in. And I couldn't see how we'd be able to get past supporting a conviction at that point. And so I filed a motion, which I think was kind of unusual, since the judge was basically ruling against the defendant. I filed a motion to have the judge reconsider it, and pointed that out to him. So, like, you wouldn't have had any way to know this, Judge. I didn't know it, but these victims were in the courtroom when this guy pleaded guilty. If they didn't know what he looked like before, they know what he looks like now. And they know that when they saw him, he admitted to doing these things. And so their identification has been validated by the defendant. There's no way you could separate those. You just couldn't. And a defense attorney would be, you talk about a Hobson's choice. Do you leave it alone, or do you say, like, you were there when he pleaded guilty? Yeah, you could probably try to say, like, in a court proceeding, you were there at a court proceeding on such and such a date, and you saw the defendant there. And but the fact that he pleaded guilty would be the validation that he made that would give them more confidence. And so if a defense attorney, even if you could kind of isolate what kind of hearing it was, you couldn't isolate the fact that the defendant, by his plea of guilty and his acknowledgement that those facts were true, validated the identification. And the witness is going to be sitting there now saying, like, well, of course it's the right guy. He told me it was the right guy.
We talked just a little bit about experts. Let's move into talking about the use of expert testimony at trial. Rule 617 says when the court admits eyewitness identification evidence, it may also receive related expert testimony upon request. So in 617, we have a may rule, not a must rule. We're going to talk about how we read 617 along with 702, along with our case law in Utah. But you and I were talking a little bit about the Utah Court of Appeals and the Utah Supreme Court and affirmance and reversal rates on the issue of admitting expert testimony. I talk to my students all the time. They have to repeat all the time. I say, are you going to win on appeal? No. Why? Abuse of discretion standard. But it sounds like maybe things are a little bit different here. And if you'll excuse me, I may have to step away from the camera just for a moment.
That's fine. Sure. Chris.
Go ahead.
So, yeah, it's really an interesting question. And as you point out, the abuse of discretion standard really does come into play. I didn't realize how precious those words were until I became a judge. and you realize, and I say that somewhat jokingly, I had an attorney when I was a very young judge that told me that if I had ruled in a certain way, that it would be reversible error. And I told him, Mr. Jones, just making up a name, Committing reversible error does not cause me to lose sleep. What causes me to lose sleep is the error that I commit that I would be convinced was error, but does not raise to the level of reversible error. And those are the backstops that we have that puts that into play. But when trying to apply this to the issues that we're talking about with expert witnesses, we have a slightly different rule in the state than in the federal system. We've already talked about Daubert and the way that's created a gatekeeper role for the trial court in determining whether or not to allow expert testimony. And most or everybody in our audience should know that that's a two-pronged standard. Number one, whether or not the subject matter is something that is sophisticated and difficult enough for people to understand that an expert witness would be able to assist the jury in understanding it, that it's not something that would be within the ken of a normal layperson. And then the second prong to that is whether or not this particular witness has sufficient qualifications and background knowledge and everything to be qualified as an expert witness in that area. And the gatekeeping role in the state under State versus Ramash is by a measure of nuance different than what we see from the U.S. Supreme Court. And the bottom line for that, from at least, this is anecdotally and just talking to colleagues, kind of an indication that there is a bias, if that's the right word, in favor of allowing expert witnesses to testify when there's a margin of doubt about that. And one of my colleagues in a judicial conference a few years ago kind of did a breakdown on the number of cases that had been considered by our Supreme Court and by our courts of appeal, or our Court of Appeal, on expert witnesses, and the number of times in which the trial court's decision about an expert witness was sustained by the Court of Appeals or the Supreme Court, and the times when it was overturned. And the percentages were pretty remarkable. And basically the lesson is, unless it just seems like a ridiculous thing, it weighs in favor of allowing the expert to testify. So in other words, trial courts were reversed much more often in refusing to allow an expert witness than in allowing an expert witness when the court thought that it was not appropriate, by a very large margin.
So the way I read, and you were talking about Daubert, I think I referred to the Utah standard as Fribert, and you referred to it as Daubert plus. Here's my reading. When we add so Ramash gets subsumed into the new 702. So when we add post 702 or amended 702 and Clopton, we say the testimony of qualified experts on factors that contribute to inaccurate witness identifications should be admitted if we can meet those requirements of 702. And after 617, it looks to me like the question is not, is this science reliable? The question under Clopton is not, would it help the jury? Instead, what we're really left with is this the right expert to present this information to the jury?
Yeah, and I think that's a fair analysis, that the first part of that standard has been conclusively established, that if eyewitness identification is a primary principal element of the trial, one of the things that's truly in question, then the defendant is entitled as a matter of right, not just to a jury instruction about the limitations and fallacies of eyewitness identification, but to have an expert testify. But it can't just be anybody, obviously. And again, I mean, the resources here are incredible. There's a half a dozen psychiatrists or psychologists at the University of Utah that testify about this kind of stuff on a regular basis, that have done the research, that are pretty unflappable in terms of cross-examination and can give the defendant a fair opportunity to present that evidence and give the jury a fair opportunity to consider how valid the eyewitness identification actually is.
We have some pretty clear case law in Utah that it's not automatically ineffective assistance to forego an expert. Are there some strategic reasons that either the prosecution or the defense would want to forego use of experts at trial where the eyewitness identification has been ruled admissible?
Oh, I certainly think so. I mean, from the prosecution standpoint, I don't know why you'd really ever want to put on an expert unless there was another expert that the defense already put on, and you're just looking to try to rebut that. And they had somebody who was really good, and you have somebody that you think can help that. But from a defendant standpoint, I think that it really depends on what your theory is about why the identification is unreliable. If you believe it's unreliable because of some of the factors that the expert would talk about, cross-racial identification, identification under stress, weapon fixation, the kind of things that we have talked about that can come into play there, then you probably would want to have an expert. But if your theory is that this person just wasn't present long enough, or they were intoxicated, or they were asleep, or they have a bias, or there's some other reason that they're identifying somebody that is not the appropriate suspect, then you might want to approach it a different way, just because you don't want to emphasize the idea that you're so concerned about how the jury's going to perceive this identification that you have to have an expert come in and say, basically, this witness doesn't know what they're talking about. Sometimes if there is other evidence that you can focus on or that's being focused on, you're better off trying to minimize the eyewitness identification as opposed to accentuate it, to put an exclamation mark on it. And if there's one thing that putting an expert on the stand to testify about it does, it's put an exclamation mark on it.
We talked, speaking of exclamation marks, I talk to my students sometimes about where you want to ask for a jury instruction, where you don't want to ask for a jury instruction, so that you're not saying, hey, important thing here to our jurors. So 617 tells us that where the court admits eyewitness identification evidence, the court may and shall, if requested, instruct the jury consistent with the factors in subsection B and C and other relevant considerations. I read this as changing the standard under State versus Long, which used to have this two-part standard. Now it seems like the two-part, it's not really two-part, it's just, was there a request or not? Is that your reading as well?
Yeah, I think it is. And the way I read it is that I am at liberty, but I'm not required to read that instruction even in the absence of a defense request. But that if the defense requests that and eyewitness identification is a central issue in the trial, then I'm required to. The defendant's entitled to it as a matter of statutory and basically in constitutional right. And it would probably be reversible error to not do that.
I hate to ask for an advisory opinion, but have you thought about what kinds of factors might lead you to invoke the may portion of the rule?
I suppose I would do that only if I heard the witness testify and I was really troubled for whatever reason about the veracity of the evidence. But I wouldn't do it without at least having a conversation with defense counsel and asking them, if they don't want the instruction, if they're not asking for the instruction, why not? What's your trial strategy here? What is your argument going to be to the jury that is not going to be enhanced by having this instruction? How do you believe this instruction may be harmful to you? And if they had some considered response, then I would probably take that into consideration. Obviously, it would be on the record, and then it would be much less likely that the Supreme Court or the Court of Appeals would say I committed plain error by not doing this even in the absence of a defense request, because I at least brought it up.
Are there model or stock instructions in Utah that have already been written on this?
Yes.
Great.
Yeah, there's a stock instruction that I guarantee every prosecutor has a copy of it. Every defense attorney that does any kind of practice at all has a copy of it. It's about 2 pages long. It's easily, probably in an eyewitness identification case, it's the longest instruction that I have to read to the jury. It's a very substantive. It's very detailed. It talks about all of these different factors, both with respect to cross-racial examination or identification, all of the factors that might come into play in making a determination whether or not somebody's identification is the product of their own memory as opposed to improper influences, such as seeing them at preliminary hearing, the lighting was like, what their level of attention was, all of the things that you can imagine that would come into play in questioning the veracity of an in-court identification are contemplated in that instruction.
And so for our new practitioners out there who might be in private practice, you don't have to reinvent the wheel. We also have a question in the Q&A right now. Where can you find those stock instructions?
I think it's a Muji instruction. I'm pretty sure that the model Utah jury instructions in the criminal realm would have that. If not, you could contact literally anybody at the Legal Defenders Association, for example, and they'd be able to share it with you at the click of an email. If they've got it on their computer, they've got a PDF of it or a Word document. And for that matter, we have it here. I have a copy of it in my own files that I use if necessary. Although typically it's always submitted as part of the stock jury instructions by either the defendant or the prosecution.
So I want to leave some time for questions. Lori, I don't know if you are going to moderate for us.
I'm happy to. At this point, there aren't any more questions in the queue. So those of you participating, please, if you have a question, put it in the Q&A feature. My initial question is, after hearing all of this, why would anyone bother? Is eyewitness testimony, I know it's more emotionally compelling, but on balance, is it worth it?
I'm not sure what you mean. Like, is it on balance? Is it worth introducing that evidence, or is it worth challenging it and going through these experts and everything?
Yes.
The latter.
Just the expense and time of trying to get an eyewitness testimony approved.
And that's a terrific question, and I think the answer from each perspective is this. In my career as a prosecutor, I became aware of the fact that juries love eyewitnesses, regardless of how we can look at the science, regardless of how we look at how reliable or unreliable they are, and all of the factors that can come into play there. There is nothing that is more viscerally influential than having a victim who has suffered a serious crime, a robbery, a rape, watching a loved one murdered, something like that, sitting in the witness box and pointing across the courtroom and saying, "That's the man that did it." And so if you're a prosecutor, that's dynamite testimony, and you want it, obviously. If you're a defense attorney, you have to recognize the fact that juries are greatly influenced by that. In my experience, and it's anecdotal, but my experience is that a jury will accept eyewitness identification the way that they'll accept DNA evidence or fingerprint evidence. It has that degree of influence on them. And at least statistically, that's an outsized influence. We know how reliable DNA is. We know that eyewitness identification is not nearly that reliable. And so I think that under circumstances where the eyewitness identification is the primary evidence against the defendant, and especially if it's a stranger crime, that it's not somebody that the witness knows either intimately or even tangentially, the guy that worked at the 7-Eleven for a while, that's where I used to see him or whatever. somebody that they've never encountered before. If there are cross-racial identification issues, if there are exposure issues in terms of lighting, awareness and things like that, I mean, if it's not ineffective assistance of counsel under those circumstances to ask for an instruction, at least, if not an expert witness, then it's really close. So I mean, I think strategically, if that's the state's evidence, then as a defense attorney, you almost have to challenge it with every resource you have available.
And we have a note in the chat box, actually, I think from one of our local experts. We should also acknowledge that identification in the courtroom is not as reliable as prior identification. And we talked about this science a bit in our first CLE, the idea that sometimes there's hindsight bias and confirmation bias. And that's one of the reasons that it's so important to get a confirmation statement at the time that the identification is made. That confirmation statement in many circumstances is a better indicia of reliability than is the witness's statement regarding their confidence level at trial.
Yeah, I mean, absolutely. If you have what you'd only characterize here as prior consistent statements that were made earlier in time before the identification was challenged, and much closer in time to the event that took place, and hopefully under circumstances that are more objective. Because as we've already pointed out, once you get to the preliminary hearing, once you get to trial, you only have one person there, and everybody knows who it is, right? I mean, you don't have a witness who is asked, you see the person in court that did this, that committed this crime against you, and have them looking through the jury box and looking through the, the spectators in the back and trying to figure out who it was. I mean, everybody in the room, even though they're not told, everybody knows who it is, right? I mean, everybody who knows who it's presumably supposed to be. And I've seen attorneys do things like try to have their clients sit in a different place in the courtroom rather than next to them. And I've never seen a judge allow that. And so, yeah, I mean, at that point, the witness is basically being asked to confirm something that they've already said under circumstances where they're basically being told, you're right, you just need to say it again.
And we also add in the fact that witnesses don't want to disappoint. They've gotten this far. They don't want to disappoint the prosecutor at trial. You don't want to be the cause that that sinks the entire case.
And all along the line, they've been given some reinforcement about their decision. If you were the victim of a crime and you went to a lineup and they said, which person do you think committed this crime? And you picked number 4. And they said, okay, great. Thanks for your help. And you never heard from them again. You'd probably think, I guess that's not the person that they thought committed the crime.
Yeah.
But if 3 weeks later you get a subpoena for a preliminary hearing, and lo and behold, you come to court and there's number 4, basically what you're hearing as a lay witness that doesn't have any experience with this kind of thing is like, I must have got the right guy, because they're trusting the police to do their job. They're not thinking for a moment that the only reason this person is here is because they identified him, because they have to understand at some level that there was a reason that particular person ended up in the lineup to begin with.
Which is one of the reasons that the instructions in Rule 617 that investigators should give a witness prior to a show up or a lineup is so important, because one of those instructions is you don't have to pick anyone. I'm not quite getting it verbatim. And regardless of what you say, the investigation is going to continue to take some of that pressure off the witness. Lori, I don't know if this is what you're getting to, but when I was doing research on this topic for a forthcoming book, I started to get really depressed about eyewitness identifications. And one of the experts that I talked to, who's actually cited in some of the studies that our advisory committee used, said, our goal with this is not to get rid of eyewitness identifications. Our goal with this is to build a better eyewitness identification.
build a better process.
Yeah, and a more reliable ultimate outcome. Because whether you're, I mean, as a former prosecutor, the investigators I work with, 99.9% of them, they're doing a really hard job as well as they possibly can. And some of the experts I talked to said the most receptive group to this science has been police officers, detectives, because the worst thing is to have the wrong person in jail and the right person continuing to victimize other people.
Right.
Yeah, so there are two threats to the law enforcement investigator, and as you point out, they are incredibly dedicated. They are, I believe, like almost universally honest. There are obviously some exceptions to that, just like there are with everything else, but they're almost universally honest, and they want to get the right answer. So the two threats are: if you don't do it right, you're not going to get the perpetrator identified, or the identification is going to be suppressed because you didn't do it right, or because you didn't do it right, the witness is going to be subject to cross-examination that really casts doubt on the accuracy and validity of the identification. But I think the primary thing that we have to recognize is that, notwithstanding the fact that you can certainly have confirmation bias, and that they believe they have the right person, they don't want to not get it right. They don't ever want to convict somebody that's not guilty, but they also don't want to lose a conviction of somebody who's the actual perpetrator based on the mistakes that they make in the identification process, which either causes it to be suppressed in its entirety or leaves open a pretty wide door for the defense to challenge the veracity of the eyewitness identification. And prosecutors don't want that either, right? I mean, you don't want tainted evidence. You don't want evidence that's going to make your case more difficult. You don't want your victim to have to go through some strenuous cross-examination like that. And that's a way to avoid it. It's just doing everything right on the front end.
And you also don't want investigators who put on blinders and trust and identification, where a witness who was asked might say in a statement at the same time as the lineup, I think it's number 4, but I'm not sure. You want the investigator to have that information so they don't put blinders on and do everything they can to just find evidence that confirms that preconceived notion.
Our hour is up. Thank you very much. I think we could probably go for another hour on this, but we'll let our participants go. Thank you very much. This recording will be posted on the law school's YouTube page within a day or two to allow you to go back and review it. Judge McKelvie, Professor Heiny, thank you very, very much for putting this together and all your hard work. And one more question, I think. Nope. Wait. Phenomenal presentation. Thank you so much. So yes, it was phenomenal.
Thanks, Ron.
And we'll see you at our next CLE. Goodbye, everyone.